In today's lesson, we will be talking about transfer of ownership of real estate from one party to the other, what that looks like, and what you need to know for the Illinois broker examination. So grab a notebook, grab something to write with, and let's dive into the course material. Welcome to this channel. I am Nonya, your real estate tutoress. I am a licensed broker in Illinois as well as a licensed instructor. On this channel, I bring you the best tips and tools to getting your real estate license in Illinois. I also answer any questions you may have about the process. If you're new here, welcome and do consider subscribing. What do you need to know when it comes to transfer of ownership? First things first, you need to know the document that's used to transfer ownership. Then you need to know the parties that are involved and the names that we call them. And we need to know what makes that document valid. So first things first, what's the document that we use to transfer ownership? That document is called a deed. All right. A deed is used to transfer ownership from one party to the other voluntarily, meaning you're either selling it or you're gifting it as, a gift or inheritance to the next person. Okay, so the deed is a document that we use to transfer ownership from one person to the other. The current owner is known as the grantor. The grantor is the one who prepares the deed because the grantor is the owner of the property and they're the ones that are transferring ownership to the recipient who is the grantee. So the deed is prepared by the grantor and it's delivered to the buyer or the person that they're giving it to, who is the grantee. Now, final thing, what makes a deed valid? There are essential things that need to be in the deed for it to be valid, and we'll talk about that next. For a deed to be valid, the following things need to be in the deed. Now, there are about 8 things I'm going to list. For the exam, I like to tell my students, don't bank on just memorizing. Understand the concept because there's only so much you can memorize and you don't want to be cramming and then it messes you up when you're going for the exam. So, understand the concept. The deed is the document that transfers ownership from one person to the other. So, do we need to know who those people are? Of course. So, we need to know who the grantor is. We need to know who the grantee is. They must be named in the deed. So we need to know who those people are. They have to be, especially the grantor who's doing the transfer, has to be legally capable, so legal age. Then we need to have what's called legal consideration. Consideration is something of value that's being transferred over. So remember that word consideration. Okay, if it's a rental property, for example, rent will be a consideration. And now we're talking about ownership. So for example, the purchase price, what the seller is getting in return is consideration. In the state of Illinois, we're not required to put the actual purchase price in the deed. If it's a gift, like an inheritance or just a regular gift, the state allows you to just put love and affection as legal consideration. If it's a purchase, the state allows you put $10 and other good and valuable consideration as the legal consideration. So once you have those in there, of course, we need to have a granting clause, the words of conveyance, the words that say you, the grantor, is giving the grantee this property. So that's the next thing that needs to be in there, your granting clause. The granting clause also determines the type of deed that's being transferred, right? So the granting clause are our words of conveyance. So that needs to be in the deed, right? We're saying what we're doing. So we've had that in there. Next thing, we need to identify the property. Which property is being transferred? And we don't use the physical address. We use the legal description. And you should have learned about the legal description in your class. So legal description is then used in the deed. Next section is for any reservations or exemptions. So anything that the buyer is taking on as they are getting this property from you, the grantee is getting, will be listed here. For example, if there are any other liens on the property that will then be transferred to the grantee, they will be listed in this section. If there are any encumbrances on the property, any easements, they will be listed in this section. Once that's done, the grantor must sign the deed. In the state of Illinois, the grantor is the only one required to sign the deed. The deed does not need to be notarized in Illinois to be valid. But if we're ever going to present the deed as evidence in court, it must be notarized. Therefore, we customarily notarize our deeds. And finally, the most important thing is delivery and acceptance. The deed must be delivered to the grantee by the grantor or their agent or their attorney and accepted by the grantee for us to have a full transfer of ownership. So when the grantor prepares the deed, we don't have the transfer just yet. It must be delivered to and received, accepted by the grantee for a full transfer to have occurred. And this usually happens at the closing table. And there you have it. Those are the things that you need to know for transfer of title in Illinois, voluntary transfer of title in Illinois. All right, so the grantor, the grantee, the deed, and what makes the deed valid. If you found this information helpful, please do like this video and subscribe to this channel. I will greatly appreciate your support. Let me know in the comments if there are other topics in the curriculum that you want me to cover. As always, thank you so much for watching, and I will see you in the next video.